Question 6, Taku to Ferris.
Tēnā koe te pika. Taku pātai ki te minita whiriwhiri take tiriti o Waitangi. Does he agree with the former minister who introduced the Marine and Coastal Area Act that his proposed amendments, quote, do not restore the original intention of Parliament, they undermine them? If not, why not?
The Honourable Paul Goldsmith.
Thank you, Mr Speaker. No, I don't. But I do agree with Mr Finlayson's statement at the time when the bill did go in 2011, where he talked about a very high threshold for customary marine title being granted. And that, in essence, is what we're seeking to establish with this legislation. And what we're trying to achieve is that balance between the natural expectations of all New Zealanders to have an interest in what occurs in the marine and coastal space, with balancing the opportunity for Māori to claim customary marine title, and there was always a very high threshold involved in that, and that is what we're seeking to restore.
Pātai anō. How many customary marine titles have been granted under this Act that will now be subject to challenge on the passing of his amendment bill?
Well, there are several cases that have been heard that will have to be reheard in the light of this legislation if it passes, and that's not something we've undertaken lightly. It's a significant thing to overturn a Court of Appeal and Supreme Court decisions, but we've done it because we believe it's important to restore that balance, recognising the interests of all New Zealanders and what happens in the coastal marine title, in the coastal area, and recognising that customary marine title grants valuable rights, including the rights to have a say over resource consents in that space, and that's why we had a high threshold.
Pātai anō. If his goal is to guarantee the rights of all New Zealanders, when will his government be introducing legislation to address the 13,000 privately owned parcels of land that actually prevent people from accessing the foreshore and seabed?
No. Anybody in a boat can access the foreshore and seabed from any particular angle.
Pātai anō. Does he consider that his decision to arbitrarily limit Māori rights to only 5% of the coastline is an example of a fair and durable framework, as was intended in this Act when it was first passed?
When I was asked for a figure, I proffered one. I point to the fact that the previous minister that the member quoted at the start offered a 10% figure at one point. Both of us immediately made the point, of course, ultimately it's up for the courts to decide where that lands through the process or through decisions made through the government. But all we're trying to achieve is not an easy thing. What we're trying to achieve, as I said, is that balance between the expectations of all New Zealanders to have a say in what goes on in their coastal and marine environments, but also to provide an opportunity to apply for customary marine title. And we think we've got that balance right, but it needs to be, it requires this legislation to be into the House.
Pātai anō. Does he stand by his statement that this bill will, quote, give effect to a commitment in the National New Zealand First Coalition Agreement to amend Section 58 of the Act to make clear Parliament's original intent, end quote? Yes, indeed.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
9 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa New Zealand.
14 votes opposed.
ACT New Zealand.
11 in favour.
New Zealand First.
Favour.
Te Pāti Māori. Te Pāti Māori. Te Pāti Māori.
The ayes are 68, the noes are 48. The question is agreed.
Marine and Coastal Area Takuta Moana Customary Marine Title Amendment Bill, second reading.